long shuttle, but we're going to go ahead and get started. Welcome, everyone. We have a training on paternity today. It is mandatory, so those of you who are here, woohoo, you have satisfied your obligation. This is the same as the one that was presented last Thursday, but not the same as any prior paternity trainings by these fine ladies. So you can get credit as long as you weren't already here on Thursday. Okay, and I will let them get started.
Hey guys, for those of you who don't know me, I'm Brooke from the Metzger firm. Today we're just doing a flyover of paternity. It's a giant topic with tons of case law, but we're going to try to hit the high points. So you're all here because switches. Okay. You're all here because paternity, I guess, is important to our practice. It determines whether your client can get FR in visits, and at the end of the FR, are they going to get custody. And you should be aware that there is potential for IAC in ineffective assistance of counsel if you don't raise these issues. As you know, the law recognizes three general categories of dad: alleged, biological, presumed, and then LCS is kind of a separate category, but Bernadette's going to talk about that. All right. First, we'll talk about alleged dads for a bit. An alleged dad is a man who may be the father of a child but has not established biological paternity or achieved presumed father status. And as stated in Emily R., an alleged dad has no current interest in the child because his paternity hasn't been established. So what do they even get? They get notice and an opportunity to appear and attempt to elevate their paternity status, and that's it. They're not entitled to custody or reunification services, and they're not even technically considered parents under WIC 317, meaning that they don't even have a statutory right to counsel. But the court in OS found that an alleged dad in that case did have a constitutional right to counsel at some stages of the proceedings. But, you know, our courts usually give counsel to alleged dads anyway. A lot of the case law on alleged dads deals with notice, and the key code section here is 316.2. It says that at the detention hearing or as soon thereafter as practicable, the court shall inquire of the mother and any other appropriate person as to the identity and address of all presumed or alleged dads. And the inquiry has to at least include all of the questions that are on the mom's paternity questionnaire, like whether there's been a prior judgment, whether she was living with a man, whether someone else has acknowledged paternity and made financial promises for financial support, all of that stuff. 316.2b says that each father who is identified shall be provided with notice at his last known address by certified mail return receipt requested. And the notice must state that he is or could be the dad of a kid that's coming under a 300 petition and that he could be TPR'd as a result. And the notice also has to include the JB 505. This is important because that is the document that allows the father to make a request to elevate his paternity status and explain his rights. 316.2 also says that if a man appears and requests a judgment of parentage, the court has to make a paternity finding. We've also got California Rules of Court, Rule 5.635, which implements 316.2. It clarifies that the clerk is the one that has to provide each alleged dad a copy of the petition, the notice, and the JB 505. And it says that the court has a duty to inquire about and attempt to determine paternity. First, the court has to figure out if there's been a prior judgment of paternity, and if there is none, they have to take appropriate steps to make that determination. It needs each dad to fill out the JB 505, and it can order genetic testing or just consider the statements of the parents. Paul H. is a case about 316.2, and it emphasizes the fact that the court has to make that paternity finding. In this case, the alleged dad appeared at the jurist hearing, which was right after he talked to a social worker and said, "I might be the dad." But the court, in this case, decided to move right along and sustain the petition, deny FR, and ultimately terminate his parental rights without ever making a paternity finding or making sure that this guy got a 505. So 316.2 not followed here. And this case is kind of sad because this guy really tried to establish paternity. He made countless attempts to try to get a DNA test. He was shot down by 4 separate government offices, including the social workers. He even submitted a packet to the court of his efforts to try to get a DNA test, which the court graciously accepted after TPRing. Anyway, the Court of Appeal found that the alleged dad was prejudiced by the juvenile court's failure to follow 316.2. They said he could have gotten that far if he had been given the chance to establish paternity, and there was no evidence in the record to show otherwise. But be aware that it might be harmless error. We've got Kobe A in contrast. It's out of Marpet's court, in which the Court of Appeal found that although notice was not in line with 316.2 and the rule of court, as to Kobe's alleged dad, the error was harmless. The father in this case was incarcerated basically the kid's whole life until just before the TPR, and at that point the kid was 5. And dad had made zero effort up until that point to try to establish any sort of relationship with the kid. The dad was provided notice of juris dispo, but it was by first-class mail, not certified mail, return receipt requested, which is required under 316.2. And he never got the petition, never got the 505, and wasn't told until the 2-6 that these proceedings could result in a TPR. Unfortunately for this guy, he had waived his right to appear at the juris hearing and checked the box saying he wanted his attorney to represent him, but he didn't have one. So he didn't get an attorney until the 2-6. Unlike in Paul H., this court in this case had plenty of information to hang this guy on. It was clear that he couldn't have achieved presumed father status even if he had been properly noticed. And the court felt pretty confident that he wouldn't have gotten that far. He had a violent felony conviction and he was incarcerated beyond the 18-month period. So TPR affirmed would have been the same result even if he had been properly noticed. In case you're wondering why I'm going on and on about notice at a paternity training, it's because there could be IAC if you don't raise these issues. And that's what happened in OS, and I think that some attorneys can relate to what the attorney did here, so just be wary. We have a dad in this case who had been seeing mom every day after conception, but she basically ghosted him when she was 6 months along, and the baby was detained shortly after birth because of mom's issues. At detention, mother identified the dad, but the court didn't make any inquiries about paternity. The case was fast-tracked to a 2-6, and months went by before the Child Welfare Agency even tried to find this guy. And they ultimately found him, but it was only because dad found them first. He was in jail, and he asked the social worker at the jail, "Can you please help find my baby?" And that's how he got in touch with the social workers. At that point, he asked for visits. They went well. He got counsel right before the 2-6, and the attorney did nothing for 3 months. His attorney probably figured this case is a total loser. He's just showing up right before the 2-6. I don't have time to work on an Ainsley or talk to a guy who's barely met his kid. So, and the attorney actually acknowledged getting several calls from this guy, some of which asked for a DNA test, but said she figured she'd talk to him at court at the next hearing. Well, she didn't talk to him at court the next hearing because she was out that day and another attorney stood in for her. The stand-in requested a continuance and DNA testing, but these were denied and father was TPR. So the Court of Appeal noted that the trial court didn't make the proper inquiries under 316.2 and the agency didn't diligently try to find dad. But most important was that dad's trial attorney failed to raise these issues and failed to ask to elevate dad's paternity status, and father was prejudiced as a result. The court said there was no evidence that he would not have received services if the attorney had done her job. The court found that this alleged dad had a constitutional right to effective counsel and that there was ineffective assistance of counsel here. And then the court vacated the TPR, ordered a new dispo hearing to occur with new counsel appointed. Here are some quotes from the case to kind of hammer it home. In the dependency arena, a reasonably competent attorney knows that notice to an alleged father is critical because it enables him the opportunity to appear and assert a position, which includes establishing his paternal status. Also, a man's status as a presumed or biological father is critical to whether he retains his rights to his child. An attorney handling a dependency matter should be aware of such issues and take appropriate steps to establish a man's paternal status if possible. So yeah, that's a cautionary tale. Last slide on notice. Alleged dads get notice of juris dispo in 2-6, but only presumed dads and dads receiving services get notice of review hearings per the WIC. Okay. So alleged dads aren't entitled to custody, so can the court even sustain a petition against them? Unfortunately, yes, per the Court of Appeal. The court in HR said that there's always a possibility that he could elevate his status. If the man really wants to deny any responsibility for the child and absent himself, he has to check the box on the JB 505 saying he doesn't want to be part of the case. That being said, that doesn't mean that we can't argue nexus, such as that our client hasn't been part of the child's life, so his actions haven't placed the child at risk. It's still something that you can try to argue. Also, the court can TBR an alleged dad without any sort of detriment finding because he's not entitled to custody. In terms of standing to appeal, basically he has standing to appeal issues relating to his parental interests, which means notice and the paternity determination. Okay. All right, bio-dads. A bio-dad is just a father, an alleged father, who's related to the child by blood. He's like an alleged dad, but he has the extra opportunity to get FR services if the court determines that it would benefit the child. And under Rule 5.635, the court can make a bio-father finding based on DNA or based on statements, testimony, declarations of the parents. Obviously, the goal is for our client to be the presumed dad, and biology is not enough to get us there. As stated in Laird versus Robertson, parental rights don't spring full-blown from the biological connection between parent and child. They require relationships more enduring. So let's talk about how we achieve bio-father status. The first way is through DNA testing, which is governed by Family Code sections 7550 to 7562. Most importantly, Family Code 7551 says that in a proceeding in which parentage is a relevant fact, the court shall order DNA testing if a party makes a motion for it at a time so as to not unduly delay the proceedings. And the court can order it on its own motion too. Again, 5.635, if a person appears in a dependency proceeding and requests a judgment of parentage on the JB 505, the court must determine whether he's bio-dad and whether he's presumed dad if that finding is requested. The court has to make those findings. Okay. As stated in Baby Boy B, 5.635 is a mandatory rule. In this case, the baby was detained at birth and mom refused to give dad's name to DCFS or the court. And when mother told dad about the baby 8 months later, dad contacted DCFS and came to the court at the next hearing, which was the 2-6. He requested DNA tests multiple times, but Judge Spear wanted to steamroll toward adoption at this point. She refused to even address paternity because Jesus, this man, might not be the father. And she called him Casper the Friendly Ghost and said that, and she said, based on absolutely no evidence, she said, I don't think he's the dad. And the Court of Appeal found that pretty ridiculous. Court of Appeal slammed her, said she should have addressed paternity, should have ordered a DNA test. You can use that if your court's giving you some trouble. Joshua R. is not such a good case for us. It deals with whether paternity is a relevant fact, which is the requirement for the court to order a DNA test under Family Code 7551. In this case, there were 3 WIC 300 petitions on this kid. In the second one, the kid was 17 months old. This man signed a form outside of court saying, I'm not the dad. A few months go by, changes his mind, sends the worker letters from jail, but he never actually came to court to request a DNA test until the 3rd petition on this kid, and at that point the kid was 5, and the request for DNA test was denied. He also had made no request for visits or custody and didn't show really any interest in the kid. Based on the fact that he couldn't have qualified for presumed and he didn't seem to be too interested, the Court of Appeal said paternity is not a relevant fact anymore, so the court wasn't required to order the DNA test. And they said the DNA test wouldn't benefit the child at this point, too little too late. In contrast, we have INRI BC from our district that distinguishes Joshua R, so we can use that. This father had no relationship with the 11-year-old kid, but he did appear in court as soon as he found out about the case and requested DNA testing. In this case, the court authorized the DNA testing, but made dad pay for it. And the Court of Appeals said, in doing this, the trial court failed to make a determination of biological paternity, which is required. And the court reversed the TPR, ordered the trial court to make this determination. Basically, they disagreed with Joshua R. This case said that the court is obligated to determine biological paternity under the rule, even if the alleged father might not qualify for presumed. They also said it doesn't matter whether it would benefit the child, the court's still obligated to make the finding. They also said the facts are different here. This guy didn't sleep on his rights. Okay. The court doesn't have to order a DNA test if we're sure he can't be the bio dad, seems obvious. Please be aware that the court can make a bio father finding even if there's no DNA test under the 5.635 in those cases listed. You can have testimony, declarations, and statements. Those are enough. You don't have to wait around for the DNA test if the parents are already sure about biological paternity. We do have in HR in which the court said that the statements made by the parents weren't necessarily enough in that case to support a bio finding. In this case, both parents said the dad was bio at trial, but the man had denied paternity several times in the years prior, so the court wasn't convinced, didn't find him to be bio. Okay, I'm just going to summarize some of the key points so far. If you pick up an alleged dad, especially if it's post-dispo, immediately check to see if he was properly noticed under 316.2 and 5.635. That means certified mail return receipt requested, JV 505, copy of the petition, warning that he could lose his parental rights. And you can incorporate this into an Ainsley motion. Second, be sure to make requests to elevate your client's paternity status, and don't forget about it after detention if you don't get the presumed father finding that day. If you don't get a presumed father finding, at least ask for bio status, and if mom's present at court, have the parents sign a VDOP in front of the court, and Bernadette's going to talk about VDOPs too. Oh, sorry. Third, push the court to make a paternity finding under the rule of court. If you want a DNA test to help elevate, but the court won't order it, you've got some case law to cite there. Okay. Biodads are not entitled to get custody. According to the California Supreme Court in Reyes D, a biological father is not considered a parent under the Uniform Parentage Act, and we have incorporated that definition into our Writ code. Therefore, the court found in that case that a bio dad was not entitled to custody under 316.2, or I'm sorry, 361.2. Just like sneak in down there under the camera. The court said that interpreting the word parent to include mere bio dads would bring in fathers who had never shown any commitment to the child's welfare and would cause services to be granted by a rapist or an anonymous sperm donor, according to the court. But yeah, they still have parental rights that can be terminated under 6. Sadly, Judge Zeidler learned the hard way that a bio dad can't get returned under 361.2 when his HOP father order was overturned. This man, in this case, didn't qualify for presumed. He was purely bio, and at a 342 dispo, Zeidler returned the child to the dad. Court of Appeal reversed. This dad was kind of creative. He tried to get around this by arguing he should get placement as a relative under 361.3, but the Court of Appeal said, nice try. What you can do is try to get the court to grant visits in the father's home, so you can argue that he's received the child into his home and request presumed, and then you're able to get custody. Oh, yes?
Well, by the time the Court of Appeal reversed, he did qualify, though, because he'd had the child in his home.
Yeah, so I think at that point, once you sent back, you get returned.
Okay.
Yeah. Yeah, so as for, yeah.
Really quickly, if the mother was thwarting the father's relationship under Kelsey S., if there's a Kelsey S. motion filed, would that have changed the analysis here?
So in that case, I don't believe, from my recollection, that there was a Kelsey S. issue. But yeah, Bernadette's going to talk a little bit about Kelsey S., for sure. So yeah, a couple things you can do. Get visits in the home. Try to get Kelsey S. status. Get the parents to execute a VDOP. Those are a bunch of ways to get to that presumed status, of course, and we'll go over that more in a bit. Biodads also aren't guaranteed reunification services. 361.5a says the court may order services for the child and the biodad if the court determines that services will benefit the child. And the idea is that it's generally in the child's best interest to reunify with a presumed dad, not necessarily with a biodad. There's not a lot of case law on whether services to a biodad would benefit the child. In my experience, the court's going to be looking at the efforts of the father to be involved in the child's life and to participate in programs. The one case I did find on the issue was Elijah V., where the court basically said it doesn't benefit the child to offer FR to a bio dad when there's already a conclusively presumed father involved, which is not a situation we really encounter all too often. In this case, the dad had no relationship with the kid, said he couldn't even take custody. What if bio dad doesn't show up until the case is in permanency planning? You've got to file a 3D8, show change in circumstances, best interest of the child. In terms of relative preference, bio father's relatives still get placement preference under 319 and 361.3. As you can see here, a relative is defined by an adult who's related to the child by blood, blah, blah, blah. So, you can try to get placement with his relatives. Be aware that a bio father's parental rights, kind of like the alleged dads, can be terminated without the court ever making a judgment finding. And lastly, a note on bypass. You should know that if a dad was TPR'd in a case where he was a mere bio or alleged dad, that TPR can still be used as a basis to bypass him to a subsequent child. All right, so we're going to move on to...
Okay, now starting with presumed fathers. So presumed father, as defined by the courts, is a father that has promptly come forward and demonstrated a full commitment to his parental responsibilities. So basically what we think of when we think of a father, a parent that's been involved in their child's life. Why is this important? As Brooke mentioned before, only presumed parents are entitled to reunification services, appointment of counsel, standing, all of the good stuff that we want for our clients. Somebody, sorry, I thought I heard something. So different types of presumed fathers. There are many different ways somebody can become a presumed father or presumed parent. It can be the husband or the attempted husband of the mother through a voluntary declaration of paternity through 7611, specifically 7611D is something that we're more familiar with. Or a declaration as outlined in Family Code 7611E. The burden is generally on the parent seeking presumed status, and they need to show proof by a preponderance of the evidence that they qualify as presumed. Now, the definitions of presumed under 7611A through E, those are all presumptions that can be rebutted by clear and convincing evidence. So, who is a presumed father? The first presumption comes from marriage, and that is from Family Code 7540. Now, the presumption of a husband that is living with the birth mother who is not impotent or sterile, he is conclusively presumed to be the father of a child. It can only be rebutted through Family Code 7541. So, under that section of the Family Code, only certain people can challenge this conclusive presumption. That's the mom of the child, the husband, the child or the GAL for the child, or a person that would qualify as a presumed parent under some other prong of 7611. Otherwise, if you have a person that comes forward saying that they are the father but doesn't fall under any of those criteria, out of luck, the presumption is conclusive. It is important to distinguish this marriage presumption from the one in 7611A. It is a rebuttable presumption. 7611A deals with husbands that are not living with the mother. And that can also be challenged, but not necessarily only through 7541. 7611B and C, I'm not going to spend a lot of time on that. It just outlines ways a person can become a presumed father if they have attempted to marry the mother, but for some reason or another it hadn't worked out. I haven't seen any of these cases, but if you have a case like this, for reference, 7611B and C is what you would look at. 7611D is what we see most often. That is when a person can become presumed when they receive the child into their home and hold them out as their natural child. Now, a current relationship isn't necessary. So if you have somebody that has held the child out as their own and taken them into their home at some point in the child's life, even though they're no longer part of the child's life, they can still qualify as presumed. Now, their current relationship may come into play later when it comes to maybe dueling presumptions, but for the purposes of 7611D, they qualify as a presumed father. Other examples, it doesn't necessarily need to be a father. Anybody who meets the criteria of 7611D can potentially become a presumed parent. One example is from a case in Reyes, Salvador M, where an older sister qualified as a presumed mother of her little brother. And that case had pretty specific facts, though. She had helped her mom raise her little brother. She was really involved in him when he was young. She even breastfed him when their mother wasn't available. Another important factor was that the mom died. The biological mother passed away when the child was really young, and since then he thought of his sister as his mother. He thought of his sister's children as his siblings. Now, the court found her to be presumed even though she had told, even though people in the family knew that she wasn't his biological mother, even though she had told school officials that she wasn't his actual mother. The court found that she was presumed, though, because in the child's eyes, she was his mother. I would be more wary, though, in cases where the biological mother is still alive and involved in the case. I think that's going to be much harder to show presumed status. So conflicting presumptions. So when there are two or more presumptions battling each other, there are two things that can happen. First, the court can weigh the presumptions and find that the presumed father is the father whose claim to presumed status is founded on the weightier considerations of policy and logic. Now, they are rebuttable. The 7611 presumptions are rebuttable, but biology isn't everything. So just because somebody is the biological father doesn't mean that they automatically win the battle of presumed fathers. The court should consider the relationship as a whole. Another thing that can happen, though, if you have more than two presumed fathers, is looking to Family Code 7612C, which says that more than two people can be a presumed parent to a child. In order to do this, though, the court has to find that recognizing only two presumed parents would be detrimental to the child. So in order to find detriment, the court needs to consider the harm of removing the child from the stable placement with a parent who has fulfilled the child's physical needs and the child's psychological needs for care and affection, and who has assumed that role for a substantial period of time. So what does that mean? Stable placement, as detailed in 7612C, doesn't necessarily mean where they're living. Stable placement, rather, is about the parent-child relationship. So just because a child wasn't living with the person who is claiming presumed status doesn't mean that they wouldn't qualify for 7612C. Okay, one case that I encourage everyone to look at, it's a good example of it, Martinez v. Vaziri. That was a case where the uncle had tried to claim presumed status. He had been involved with the mother since she was pregnant. He was present for the birth. He had lived with mom at some point, but had moved out and continued visits. In that case, the mother said that he didn't live with the child and she would keep him involved in the child's life, but the Court of Appeal said it didn't matter that he wasn't living with the kid, it didn't matter that she had promised to keep him involved. His relationship made him a presumed father. So again, be wary of promises to keep this non-biological father involved. I think of it as kind of similar to when we have adoption cases and the prospective adoptive parents promise to keep the biological parents involved. ask the court to not give that any weight. It's about the relationship between the parent and the child, so always imagine that the worst case scenario will happen. They must have an existing relationship, so this is where it comes in if the person had held themselves out as a father and later disappeared. The detriment must be current. So it shouldn't just be if there's a biological father there that could have a great relationship with the child, is otherwise a great guy, that doesn't matter. If he doesn't have a current relationship with the child, he should not be found to be a presumed father under 7612C. It's not enough that the child might suffer harm by not knowing who his biological father is or not having a relationship with this person. That doesn't matter. If they don't have a current relationship, they don't qualify under 7612C. And the quality of relationship matters. If he's a father in name only but doesn't fulfill any of the parental roles or responsibilities, then he shouldn't qualify under this. If the children know who their real father is, likely doesn't qualify under 7612C. If they have a bad relationship, then it's not really going to help their case. For example, I know sometimes we have D cases where the offending parent requests to be presumed of the victim in the case. It's not really the strongest argument because the court, again, considers whether or not they're acting in a way that a parent should be acting. So if they're not doing that, then it's going to be a little bit harder to make your case for 7612. Yes?
If there's a presumed father that is presumed because he's on the birth certificate, and a second father is requesting presumed status, does the first father have to be noticed for that hearing for the second father? Do you know?
I mean, I don't know off the top of my head. I would assume so, though. If somebody is challenging the presumption, I mean, we don't know what's necessarily going to happen. They could end up not being presumed because of that. So when there is any kind of challenge to any kind of paternity status, I think they should be noticed. Now moving on to Kelsey S. father. So I think sitting here listening to all of this, you think, oh wow, this is really hard on the dads. They have to do a lot, they have to show a lot, and it's really difficult. So the Supreme Court thought of that, and they saw that there was an equal protection issue. So their solution to this was Kelsey S. So basically, Kelsey S. says that a father should be allowed to withhold consent to an adoption, and parental rights can't be terminated for him absent a finding of unfitness. Now, only certain fathers meet this criteria, though. Okay, so Kelsey S. father is a biological father, sometimes. A Kelsey S. father doesn't necessarily need to be a biological father, who has promptly come forward and demonstrated a full commitment to his parental responsibilities, but has been prevented from doing so and from getting himself to presumed status because of some interference by the mother or a third party. And Kelsey S. applies to dependency proceedings. It was originally a family law case, but it does apply to our courts. So Kelsey S. factors. So you must consider the conduct before and after birth. So once the father knows of the pregnancy, he must attempt to assume responsibilities to the extent he's permitted. Obviously, if he's not allowed to be that involved, the court should take that into consideration. He shouldn't just want to block the adoption, but he should also be willing to take full custody of the child. It's not enough that, oh, I don't want my child to be adopted. You have to be willing and ready then to take the child, raise the child on your own. You have to publicly acknowledge paternity. You have to contribute financially to the best you're able to, though. The court takes into account the financial limitations of the parents. You have to emotionally, physically, and financially support the mother, and you have to notify mother promptly of the opposition to adoption. Now, not all the factors are necessary, but they must be carefully weighed. Oh, one thing I want to go back to, if you have a case that you think might be a Kelsey S. case, I encourage you to go to the adoption of baby boy W. It pretty clearly lays out all of the factors. What isn't a Kelsey S. father? So if you don't ask to be a Kelsey S. father, you're not going to be a Kelsey S. father. If you only request presumed and then you're turned down and that's it, you're not going to be able to appeal this issue because you will have essentially waived it. If you only contribute sporadically or in small portions without showing that you are financially unable to contribute more, you won't be a Kelsey S father. If you're not actively attempting to assume parental responsibilities or attempting to take any legal action to gain custody of the kid, you won't be a Kelsey S father. And if you don't show a willingness to financially or emotionally support the mother, you won't be a Kelsey S father. So there are a number of cases about Kelsey S and how it should be applied. I have found the courts have been pretty lenient in the behavior of the father in terms of what qualifies as a Kelsey S father. Now, the adoption of TK outlined somebody who wasn't a Kelsey S father because of pretty bad behavior. So he had planned to have a child with the mother. They broke up, they got back together, they broke up, they got back together. They established a baby fund, he contributed to it. He took a parenting class, he bought baby supplies, did all these great things. But he had took all the money out of the baby fund that he had put in, and he never put it back. The court called him creepy. He cyberstalked the mother. He showed up at appointments that he shouldn't have known about unless he had access to email. He lied to the court. He falsified check registers to try to claim that he was contributing to the baby financially, even though he actually wasn't. So the court said, no, this guy cannot qualify as a Kelsey S father. He not only did not contribute financially, he was basically not supporting mother emotionally because look at all this awful behavior that he was in. Now, their decision directly conflicts with another case, HR, that also had really bad facts. But in that case, the court found the father to be a Kelsey S father. He didn't contribute financially, but the court said it was okay because he owed $18,000 in child support and $15,000 in court fines, so he couldn't contribute financially. The mother also said that she had tried to get a restraining order against this guy because he had a meth addiction and he displayed domestic violence tendencies. The court said, that's okay. She didn't successfully get a restraining order, so clearly there wasn't enough evidence that he was a bad guy, therefore he's a Kelsey S father. So I just want you guys to know that if you have clients that have bad behavior, that haven't had the best relationship with the mother, there are plenty of cases for your fathers. There are plenty of cases out there where the courts have been very forgiving of bad behavior by potential Kelsey S fathers. So just be on the lookout for that.
And one quick note to address Jabron's question earlier about ET and whether Kelsey S could have been argued. I think it could have been argued in that case, but because at the trial court level the dad never requested Kelsey S or presumed status, we waived it, so that's why it wasn't really addressed by the Court of Appeal.
And another thing on that, are Kelsey S fathers presumed? There's a split of authority on that, and the split is within our own district. So it's unclear whether they're actually presumed, but the more recent cases say that they are, so I would argue that. The case that says they aren't presumed is Division 5. It's N. Ray Vincent M. And it said that Kelsey S never said that Kelsey S fathers become presumed. It's nowhere in the case, so we can't really make that assumption. But a more recent case, N. Ray MC, that's from Division 1, said that because of the constitutional rights that Kelsey S was meant to protect, it overrides any contrary statutory direction. So therefore, somebody who qualifies under Kelsey S is a presumed father. So what to do with the Kelsey S? Ask for presumed. Say because a person qualifies under Kelsey S, under N. Ray MC, that they should qualify as presumed. Mention the constitutional argument, mention the purpose of Kelsey S, equal protection for these fathers who have otherwise stepped up to the plate and attempted to be involved in their child's life. If not, at least ask for the opportunity to attain presumed and be involved in the case. Can the parental rights be terminated? Yes, as long as some finding of detriment is made. So, voluntary declarations of paternity, otherwise known as VDACs. So it is basically equivalent to a judgment of parentage and confers on the parent all rights and duties of the parent. I put two different quotes because one thing I want to mention that everybody should be aware of is that the language of the Family Code is changing, effective as of January 1st, 2020. Most of the changes reflect a more gender-neutral approach to paternity and families in general. A lot of things have been moved around, so please be aware of that when you're referencing the Family Code in court. So what's a VDOP for? Generally, an unmarried woman who has given birth to a child, or married and unmarried woman who gave birth to a person who is a parent under 7613. In practice, when do we see it? When a mother has given birth to a newborn baby, the baby is immediately detained. Everybody agrees that this person is the father. Haven't had time to sign the birth certificate, do all of that. So what do? We sign a VDOP in court. Who can't use a VDOP? A sperm donor. Somebody who already has a presumed parent under 7611 or 7540. If another person has already signed a valid VDOP, you cannot use a VDOP for your parent, or if the court has already entered a judgment of paternity. So the checklist, yes.
This sperm donor, are they entitled to notice, or does it depend on how whether they informally donate the sperm or do it contractually and waive all rights? Do we know?
So I don't know off the top of my head. I know 7613 pretty clearly outlines the rights and the process with regards to sperm and ova donors. I believe there is something that they can fill out with regards to somebody being the intended parent who isn't the sperm or ova donor. So off the top of my head, I don't think they have any rights, but if you have a case with a donor, 7613 is where you would go to look. So you need the name and signature of the mother and the father. You need the name and the date of birth of the child. The declaration should be made available at many different places, including our courts. And I've heard that there have been some pushback by the clerks of the court to be witnesses and to sign the VDOPs. It's in the code 7571 that the staff at the courts shall witness the signatures. So if they give you pushback, show them the code, they have to do this. Technically, they're supposed to mail it out too, but it's generally something we do. Make sure that the declaration is sent to the Department of Child Support Services within 20 days, otherwise it won't be valid. So does a voluntary declaration of paternity mean you're presumed? There is a case in Reyes that says you aren't presumed necessarily because a judgment of parentage, a judgment of paternity is not the same as a presumed finding. However, that case was referring to a judgment of paternity dealing with a child support case. There is more recent case law that says that a VDOP means that you're presumed. And there is also California Rule of Court 5.635C, which basically says that if you properly executed a VDOP, you are presumed. So the miscellaneous, the presumption is not rebuttable. However, it can be challenged by the non-donor genetic parent.
So at the time that you file the VDOP with everybody in the court, can you ask for presumed at that time? And if the court denies the presumption status and says that, for instance, I had some pushback in Department 410 asking for presumed father when you do the VDOP in court, and I was told basically until it's really truly filed in Sacramento and all of that, then you could give weight to it, to being a presumption status. Are you saying that once all parties agree to the VDOP and we file it with the clerk, then at that point it can and should be presumed?
That's how I've always done it in practice. I've never had that happen to me where somebody says, oh no, you need to wait till it's properly filed. If that's the case, I mean, technically, if it's properly filed and executed, that's when it can elevate you to presumed. So you may just have to say, okay, fine, can we come back in 20 days when it's been properly filed, then he should automatically become presumed.
So then your suggestion is to ask for a progress on the
If you
paternity
could.
status, that way you can put it on the record that this is actually filed and actually presumed at that time, and then you move forward from there.
And the proof of mailing and everything, but I've always had it, in my experience, maybe I've just been lucky, the court just grants it, and they assume that we're gonna mail out and file it properly.
No, like 9 times out of 10, that's the way it is.
Yeah.
But when you are getting pushback about somebody being presumed, then.
Yeah, that's the only thing, because technically, yes, it is when it's properly executed and filed, because just signing it isn't necessarily enough, because there are a ton of things that can happen in between. And there have been cases where the attorney, things weren't properly witnessed, or things weren't properly sent in, and that, it's not valid. So I kind of get where the court's coming from in that, but I would just ask for a progress, and you can bring all the proof of mailing and everything like that.
Thank you.
It can be rescinded. If the rescission can be filed within 60 days of execution, and it can be set aside. The court can only set it aside though if it finds that it isn't in the best interest of the child. So if they find out another man is the biological father, they're not going to set it aside unless it's in the best interest of the child to set it aside.
I have a question about the rescission.
Yeah.
Is there, how do we help our clients do that if they need to? Is there a form that we get, or?
I don't think there's a specific form, but the whole process is basically laid out under 7575. I would make that request in court. I don't think I haven't seen a proper form. I don't know if anybody else is aware of one.
I think there is a
There
form,
is?
yeah, and do you actually have, it's on the Paternity Opportunity Program website.
Okay.
They have a specific form. Do you know if the Paternity Opportunity Program has in fact, like, because I was in contact with the person in charge of the whole VDOP thing within the last year, and they said that currently our court, Edelman D. Children's Courthouse, doesn't have any registered agents who are actually trained and authorized to witness the signing. Because they won't accept it and it will not be filed. So we will send it and they will not accept it for proper filing, and it will never be a validly filed VDOP unless a registered authorized agent for witnessing is in place. And I'm just wondering if
Okay, so everyone just forget all of
No, I mean, we should still be doing it because, like, the judges don't know that that's the case.
Yeah. Well,
But I don't know if,
it just seems
Clerk is
odd.
authorized to do this.
I mean, it says in the statute that they're authorized to do
Clerk
this.
is authorized.
So, I mean, I think that just
okay.
it just seems to directly conflict with what's in the family code saying that they shall witness this. So I don't know what they would expect. If these are supposed to be made available and witnessed by any staff at any of these offices, including courts, it would be weird that you would need a specific certification to do it.
No, I agree, and there was back and forth. I was just wondering if anybody had recently had the court clerk still push back, or if they're backing off of that.
There's a little pushback.
Yeah.
We've been doing it though.
Okay.
Yeah, they do that.
And I haven't been getting them sent back. Has anybody else?
No, I haven't.
Yeah. I send them off and then never hear anything, which I assume means it worked.
No, they just don't get filed.
Worth noting, we end up getting a lot of these VDOPs where the parents know at the time of signing that the person signing is not the biological father. That's technically fraudulent. So just be aware of it, because there's an awful lot of people that come in and have to sign VDOP and they're not the biological father, and that invalidates it. I saw, you said that there are cases where they have to say that it's not the best interest, but I would question if the parents knowingly signed it.
Yeah, if it's fraud, then it is invalidated. So tell your parents not to lie on the forms. Any other questions? Oh, you know what, I did have one last slide, I lied. So just because paternity is such a big topic, there are a few things that I couldn't cover. Again, the Uniform Parentage Acts are changing. Refer to your updated code books when referencing any kind of paternity statutes. For sperm and ova donors, go see Family Code 7613. It does pretty clearly outline the process for that. Same-sex cases, I know I didn't go into that today, but it is likely to become more and more of an issue. So here are some cases that could serve as pretty good starting points if you have those cases. Thank you.
If you came in more than 10 minutes late after I'd taken the sign-in forms, you can sign in for partial credit here, and you can come to me or Gibran for your certificates. Okay. Give me a second. All right. I won't take your word for it. Just give me a second here. Thank you. Thank you. Sorry. That was the funniest thing I've ever seen. James here, girl. Oh, that shit was good.
Not get on camera.
If you're here more than 10 minutes, you have to say like a percentage of the hours. We don't want to lose our MCLE.